Okay. All right, everybody. Welcome. This is Curt Verone,
And Brad Pinsky.
and we are here for another edition of Fire Law Roundup. This one is actually for tomorrow, for January 22nd, but we're doing it on the 21st. Brad, go ahead. Take us away.
Hi, let's start in Ohio. And, this is another good example of how medics can get, or EMTs can get themselves personally sued. Now, again, this is an allegation. This is a lawsuit. We're not saying this happened, but the lesson you're going to get when we go through this is remember, there's electronic devices everywhere, and everything you have done or haven't done, the absence of what you did do, right, will come back to haunt you or hopefully save you. In this case, we have the estate of a man in Ohio. He died of an overdose. He was at a was this the one who was at a homeless thing?
Yeah, I think he's a homeless man who was at a city warming center. And
Okay.
they actually had a medic on duty. The fire department had a medic on duty, and then they called for an ambulance
And
for
which should help, right? But the medics allegedly, because the two medics are being sued, allegedly did nothing. They didn't monitor and they didn't render aid. Allegedly, then they dropped the dead body off at the hospital, make some jokes or comments about it. And remember, so you've got, if you monitor the person, there's, electronic recording of that. If you didn't, you better explain why you didn't. And if you didn't treat the person who was coding, or you didn't know they were coding, or you didn't monitor them, this is not going to end well. So additionally, however, there's allegations that these medics falsified and withheld information in the pre-hospital care report. So apparently there was a criminal investigation and nothing has been filed yet, if at all. This is, you would think there would be something that would have happened since March of 22 if there's going to be criminal charges. If the investigation credited the allegations as true, I have a hard time believing how there would not be a criminal, right?
especially after what we just saw in Aurora, Colorado, where you had medics who were trying, but they administered maybe too much medication. At least that's the allegation. That they were actually found guilty of I guess it wasn't manslaughter, but it was a negligent homicide or
Negligent
whatever
homicide, yep.
whatever it was. Here, the allegations anyway are that, and there was two people involved. There was a medic in the back of the EMS unit. There was an EMTB driving. And I have a little bit more sympathy for the driver if the allegations are true. But he didn't really come forward. The police report was attached to the complaint. That's why I included it. And there was some misinformation, whether it was misremembering or there was some intent to sort of trivialize some of the things that happened there. And it just, as alleged, it looks really bad for both of them, and certainly for the fire department. So
Yeah, just
not what we want to see.
if you're anybody, don't even put yourself in this position. I mean, God, at least put a monitor on if you're a medic, and follow the protocol. Follow the protocol. Your personal feelings are irrelevant.
At any rate, I will put whatever else I can get on this case, because I think this is a really good case for EMS instructors to kind of go through. I think maybe things that we tend not to do on the EMS side is go through case studies. We try to do it more on the fire side, but I think this is a pretty good one. There's some other ones out there, certainly, but there's some lessons to be learned here. And certainly your point about the videos and the monitoring, and this particular EMS unit had cameras on it. So these two were apparently recorded. The medic and the driver were recorded having a conversation. I don't want to get into the language that they use, but you know, they pretty much buried themselves. If assuming that the video, you know, accurately depicted, or the complaint accurately depicted what was in the video. It's hard to explain that away. So
It is. And we'll see other medic issues coming up. So
yeah,
now let's go to Chicago, because it's another example, right? And both of these you and I are going to cover at my conference in depth. But the city of Chicago, you posted this, so I'm curious where you got the phrase from, and let me go through it, and then if you could answer is you said the city is poised to settle a wrongful death suit, which you and I covered, right? For $5 million. And basically what happened is the fire department, Chicago Fire EMS, responds to a well-being check. They believe the patient was dead on arrival. You all could predict where this is going correctly, right? And they don't exercise any care or diligence to make sure that the person's actually, you know, dead, clinically dead. They don't obtain vitals, hook up a monitor, etc. And then they leave, and then they get called back, right? Like, hey, the person's alive. You're wrong. And we see a couple of these. There's like 1 or 2 a year of these, which
it's a little bit more. We cover it here, probably 1 or 2 a year, but I see a lot more. That there's only so many that I can cover, but I have a category in my database, a little checkbox for mistaken DOAs. So that's where I came up with it, but it's basically where we go to a scene, we draw a conclusion that the patient, you know, is dead, and it turns out that we were mistaken for some reason.
And we got a third one coming up in another minute. So, but and here look, the person was face down, cold, blood pooling, right? So maybe they tried to use the obvious signs of trauma, but I got to tell you, I'm 100 times out of 100, unless there's maggots coming out of their ears, I am hooking up a monitor. Just that. And I want to tell people that a good friend of mine who works for the state, I remember a decade ago, he went to a call and there were literally maggots everywhere on this body, and it was jello. The body, I mean, you couldn't touch it, but they put a monitor on and they had a heartbeat.
I had a similar thing happen, you know, and we had a guy who was sitting on the throne, and he was as rigid as you could. It was difficult for us to get him off the throne and get him prone so we could start CPR on him. But I was on an engine company, and you know, he was rigid. I mean, and he wasn't breathing, or at least as far as we could see, he wasn't breathing. Medics got there, they agreed the same thing. They put him on the heart monitor, and he had a heartbeat. And so all of us are looking at each other, and we check with the wife, and she said he does not have, you know, any sort of pacemaker. And so we worked him, and he didn't make it. But still, you know, you've really got to put him on the monitor. I mean,
you don't want to be facing an allegation ever, because at the minimum, you're probably losing your job. Right. Yeah. And you're probably not going to get hired because you're marked as that type of person. You just don't want to be in that. So put a monitor on everybody, follow your protocol. And even though there's a protocol that says obvious sign of death, it better be headless, right? Better be headless. So I be careful. Okay. New York, this, you know, I'm trying to bite my tongue on this.
Tell me about this one. Will you tell me what is going? I've seen the videos, and I'm assuming that this is one of the things that we see in the videos. But what in God's name are they doing?
So, okay. So first of all, the sport is great. It's a drill team sport in New York. It's exceedingly common. We have things called A trucks, B trucks, C trucks. The C trucks are very fast. Typically, they're B trucks and C trucks, but these are things that go from 0 to 50 very quickly. These firefighters jump off. One of them hits a hydrant, one may climb a ladder, and you see them flying up using the velocity of the truck, hitting a bridge. They climb up like a little monkey, and they, you know, ring a bell, and it's drill team. It is so much fun to watch. But here's my issue. There's no way in hell that's a drill, right? Because I've never seen, and hope to God to never see, a fire fought that way. Maybe when we were using bangers, right? Maybe that was how we got the banger up the place, but drill teams are still around in Western New York, very popular, Buffalo area, and downstate, the drill teams, and public money is spent on them, which I think is a waste of public funds. It's a sport, but it is literally in New York State's law still, and nobody, including me, is dumb enough to challenge it, to engage the wrath of everybody. So here we have a firefighter who's injured on a track at a drill team competition. He claims the driver was negligent. Look, the whole driving is negligent, period. I mean, these things go from 0 to gazillion so quick. People are barely hanging on. They're not seatbelted. They're jumping off when this thing's still moving. I mean, this is crazy. And if you haven't watched it, watch it. If you have not
I've watched the videos.
They're awesome. Awesome. But the legal issue is, if you are a volunteer firefighter in performing in a drill and you were injured, your exclusive remedy is at least as against, right? Your exclusive remedy as against your fire department and any other mutual aid department and any trainer helping out. Your exclusive remedy is basically workers' comp. Now, we call it volunteer firefighters benefit. It's a list of better benefits than just comp, because you wouldn't want to get 2/3 of your volunteer salary, which would be zero, right?
So zero is zero.
Zero, right. So this firefighter, this individual got, the VFBL, but then tried to sue, saying, I want more money for pain and suffering, other things. He can't, the court said you can't. You got VFBL and that's all you get. And that's the law. I'm surprised they sued at all, because that's pretty straightforward. But they tried to sue the landowner. In that regard, they might have had a good claim, except they sued the wrong entity. They sued Ridge Fire District, who didn't own the land, so they blew it as against the landowner. Landowners can have liability. I don't know how it would have related here, like they let it, they had a trap or they had a pothole or something, and it was dangerous, and they knew it was dangerous, but they sued the wrong entity. They threw it out.
Workers' comp exclusivity, really, it covers the employer and then colleagues. And I think mutual aid, you can argue mutual aid. There's actually some cases out there that talk about whether or not mutual aid is or is not, protected by that. But it's not going to stop you from going against a property owner or a house, if we're talking about at a fire scene, a homeowner, or someone else whose negligence may have contributed to it. It's really just limited to the fire department and colleagues, and that's who he sued. So,
yeah, the court's right. I mean, the court got it right, and I would have told the guy, don't bother suing, but whatever happens. Okay, now this is a good lesson for collective bargaining. I'm curious I'll go through the facts, but I'm curious if you agree with the arbitrator, because I really am not sure I do. I haven't read the CBA, but here's what happened. Very simple facts. We're in Washington State Fire Department, and there's a firefighter who, and this happens a lot, and I understand all the frustration of municipalities. I really do. You hire somebody, you train them, you pay a lot of money. Either you send them to the academy. In this case, they took a paramedic course. You spend 10, 20, 30, 40, 50,000 on them, and then they leave. And they take their training and they go somewhere else. And you're pissed off because you've invested money. So there's a CBA, remember, which protects the employees, right? There's a CBA, and the CBA says that if you leave within 5 years on your own will, we didn't terminate you, then you have to reimburse the fire department or municipality for those costs. But it says out of your last paycheck. And the question here is whether
who put that language in there? Who put that language in there?
Yeah, well, definitely
a very good smart union official or an attorney who was saying, "Hey, just sneak this language in there."
And that was, and they did, and somebody didn't catch it. They, here's my thing. I didn't read the exact language, right, as the whole phrase would have been, but if it clearly limited the arbitrator, right, not a judge, but an arbitrator who they agreed to, I think, final and binding. But the arbitrator said, look, it clearly limits to the last paycheck. I don't know. I don't know if the arbitrator is a lawyer. A lot of times they are. I don't know if they're a labor lawyer. A lot of times they are. Most times they are. You're choosing from a list. So they probably know what they're doing. But wow, Wow. So they limited it to the paycheck. So they wanted $60,000 or no, $29,000.
They
But
reduced it. They initially wanted close to 60, and then they reduced it down to 30,000. So yeah.
yeah, and then the arbitrator says, sorry, you only get the last paycheck. And the funny thing is the last paycheck, what if I only worked 1 day? Right.
Yeah.
And that was my last paycheck versus I worked, it's 2 weeks. I mean, it's insane. Somebody missed the,
It's tough. And, I kind of added a little bit there because this becomes a big issue for us when we look at the FLSA aspects of it. And there's a provision in the FLSA that's intended to prevent an unscrupulous employer. Like, let's say a hypothetical big box store called, and we use this in our class, called Walmart, not to be mistaken with another big box store with a similar name, but Walmart, sends people to train on how to collect carriages. And that if you're going to leave Walmart, who pays you minimum wage, if you're going to leave Walmart, in the next 10 years, you're going to have to repay them for training you how to pick up carriages. If an employer can get away with that, I'm not saying that's what fire departments are doing. I'm not. But the law is intended to prevent unscrupulous employers from pulling crap like that. And the way it's written is when you pay somebody, it has to be free and clear. And when you do things like this, it's not free and clear. In my opinion, it's not free and clear. That you're saying that we're going to hire you, but in order for you to be of any use to us, you have to go to this training. We can't use you if you're not trained. So the question becomes: is the training for the benefit of the employee, or is it for the benefit of the fire department? In my opinion, pretty clearly, it benefits both, but pretty clearly, the person is of no use to the fire department if they're not trained. So the fire department is getting some benefit from it.
Yep, I agree.
By the way, police departments have the same issue, maybe even worse. Okay, because my son went through the police academy, and he said a number of times, a police officer, it was a state academy, so all municipal officers go. But on a Friday afternoon, an officer would go home in one uniform, and Monday morning he'd be back in a different uniform because he got hired by a different department, typically bigger, typically pays better. But the original police department that hired him basically paid the tuition, and then certainly the wages up to that point, and then the other police department took over the wages. But to me, this is something that needs to be addressed on a fire chief's level. The state chiefs ought to get together and say, look, if we're going to be poaching each other's people, let's work out some sort of compensation. Don't put it on a poor kid who's 19, 20, 21, 22 years old and it's got to make important life decisions. Don't burden that kid with that. Really. And I think that's the intent of what the FLSA is saying, that, you have these, whether you call them clawback provisions or, it's like creating indentured servants. When you do stuff like that, there's a problem. I'm not trivializing the problem. I just think the solution is for the chiefs in the state to get together and fix it at their level, not at the individual employee level. I just think it's unfair. That's my take on it.
And we, in my area, we have 3 combination departments, and then we have the city of Syracuse, and the city of Syracuse is doing structure fires all the time.
And where do guys want to go?
Right. They want to go fight fire.
Right.
So they get trained here. They get on the job here for a couple of years. We spend a lot of money training them. They become semi-senior. Maybe they hit lieutenant, maybe they don't, but then they're off to the city as a lateral. Absolutely. The city gets the benefit of the lateral transfers, and people are upset, but what are you going to do? I will make
again, it's going to be fixed by the chiefs. I don't think it's fair to put it on the kids.
I agree. And I think the departments may have to reimburse, right? Because they're saving.
That's what I mean. Really.
Yeah. I mean, let there be a special state law maybe that says one department shall reimburse 50% or whatever. So something, but anyway, okay. So good topic. I will make one last comment on that one though. New York State has a law, I think it's labor law 180, 181, that says you can't deduct anything from their last paycheck. You have to pay it. So this wouldn't even be allowed at all. It would raise more interesting issues. So if you're a New York department, I'm sure a lot of other states have a similar law, and it says you can't take anything out of the last paycheck. You have to pay it. You can't withhold whatever. It begs the question, well, then this judge's ruling could have been, right, you can't define a contract to be something that's illegal. So they
Right.
would have had to interpret the CBA as, well, it
Mhm.
can't mean that because you
Well,
can't deduct anything.
this agreement could have violated the FLSA, because if this would put him, if they took his entire paycheck and he did not get paid for certain hours, that would violate the FLSA, because he's entitled to at least minimum wage.
And
You know?
so maybe where the arbitrator got this wrong is if the state or the FLSA applied, if state law or FLSA applied, you can't interpret a contract such that it would be deemed in violation of the law. You have to presume, right? So in
Well,
that case, the
we just
arbitrator
gave the
here might
fire
be
department
wrong.
an appeal.
Yeah, that'll be $400. No, okay. So, but I think it is an issue, right? I do. That was what struck me is if this was in New York, I don't think that would be a legitimate way to interpret the contract, because you can't interpret it that it would violate the law, and that would mean you have the right to get it from them. You just don't have the means to get the money from them, right? You could get the money, right? You could sue for the money, but you have no right to take the money. And that's how New York works it. Anyway, okay, lastly, and this just continued, maybe we should have done it all in the row, but we have another allegation. Now, this one, I'm more on the fire side, right? I don't know. So vague, but we're in California. We have a lawsuit where California sued over not pulling somebody out of a vehicle for a very long time. And allegedly, right? And we can all see this, obvious death, pinned, whatever. But it's the Hemet Fire Department, the mother of a guy who was killed in a vehicle accident last year, and in January. So this is a year, not that long. And he sued the police department, but they said you didn't rescue my husband. He was in a car. And
My son, her son.
Son?
Yeah,
oh, yeah, son. Mother, of course, son. Yeah. So what happened is very quickly that the vehicle was exiting the mobile home park, was attempting to make a left turn onto an avenue, struck the decedent's vehicle, right? So there's this car accident, has nothing to do with the fire department yet. So the decedent's vehicle swerved into a ditch. Now it's a drainage ditch. So we're going to pull somebody up, right? We're going to crib and shore and cut, and we're going to flip or do whatever to this vehicle to get this person out. But they said they breached it. They're accusing the department of you didn't even try to rescue him, and he was there for several hours, and they did nothing. So I've got to imagine they crawled in, put a EKG on him, said, okay, obvious traumatic death. I don't know. But yet again, we have another lawsuit.
Yeah, and I want to just kind of fill folks in on this one. I got a call. I posted it. I don't forget if it was Monday of last week. At any rate, the day I posted it, the following day, I got a phone call from his mom, the plaintiff in the case. She filed a suit pro se, and she was pretty upset with me for writing about it. She's like, "Who are you to be writing about this?" And about it. So I explained to her, and I explained, my the reason why you and I do this, and the reason I do the blog is to educate firefighters as to what's going on, so we can get better. And that the lawsuits, in some respects, they can represent a failure. Not every time, but they can represent a failure. And if we understand our failures, just like when Billy Goldfeder looks at a line of duty death, NIOSH looks at a line of duty death, we're trying to get ourselves better, and we're trying to educate. So I went through that, and she was very not apologetic, because she's distraught, but she understood. And then I said, if you don't mind, I've got some questions for you. And she shared some of the details, and I think the details are important for us to understand, because I don't think this is the last time we're going to see something like this. Okay, and she was saying that she's obviously very close to her son, and she was monitoring his travels. I thought she said he was coming home from work. I may be mistaken, but she was monitoring him, just like I know my dad and my wife. They watch where I go. Through my iPhone. And she was watching him, and she noticed he stopped. And she was only a couple of blocks from the house, but he had stopped. And so she waited a little bit, and then she went out to see what was going on. And she saw the police cars, saw the fire trucks. No one would let her near the vehicle. She said, I think it's my son, and they wouldn't let her near the vehicle. So she was upset about that. And I get it. I wouldn't have let her either. Okay. But the next thing that she said was that, and I didn't want to pry too much into the details of what she knew and when she knew it, but she said that his iWatch showed that he had a pulse after the time that he was pronounced. And that's sort of the root issue in her lawsuit, is that she wants to know, how is it possible that his iWatch said he had a pulse at a point in time when the fire department already declared him dead? And there's a lot of ways we can look at this. Maybe the watch was off. Maybe there was some timing issues and so on and so forth. A lot of different factual issues. But my point being, as firefighters now, we're used to having, well, first of all, we're used to working on less than 100% of the information.
Right.
Okay. But one of the places that we don't typically see reliable information coming from would be family members at an incident scene.
True.
And today, with technology, that could happen. That could very well happen. In fact, another way that this kind of information could find its way to the incident scene is through the dispatch office, because it may be the dispatcher that takes a phone call from a parent or a friend or someone who's saying, he's got a pulse. What are you doing declaring him dead? And the dispatcher typically isn't going to give out much information, but the person who's they're talking to has got to feel like, this is the way that I'm going to get information to the people at the scene. So I don't know. I kind of think that this could be sort of the tip of the iceberg, because I know my watch, I've got a Garmin watch, and it tracks my pulse. It does my pulse ox, does a lot of different things. So I don't share the information with others, and I'm not even sure that it's capable of doing that. But that technology is coming, and when people who are not at the scene may have information that the people at the scene don't have, and maybe the people at the scene think they've got it right, but there's other things going on. It just opens a lot of other possibilities for us that we have got to be paying attention to, because even if she is wrong, okay, even if she's dead wrong, the fact that no one would listen can turn into a media problem for us, perception problem for us. So I'm very sympathetic to Mrs. Davis, and certainly for her loss. I'm also sympathetic to the Hemet Fire Department. Very squared away fire department. They, I know some of the folks in that department.
But if they put a monitor on and the monitor shows pulseless, look, and by the way, let me go back to my EMS days. There's PEA, there's pulseless electrical activity, and right, which the watch may pick up, but it's not rendering. They're still not registering. They're asystolic on the right? There's no pulse, but there's electrical activity, but it's not going to pick up on a monitor. Maybe the watch picks it up, maybe not. I mean, there are explanations for how, I'm not saying mine is it, but for how the watch could do it. But I agree, there's so much technology out there that's going to play into what we knew, should have known, could have known, should we even have been aware of it. We're not going to check someone's watch, right? We're hopefully putting a lead, and hopefully the department put, a 3 or 12 lead on the person. If they're trapped in a car, probably a 3 lead, and confirmed asystole. And if there was obvious traumatic death on top of that, so I understand the mother, she's faced with a very valid question. Doesn't mean the fire department was negligent. Right.
No, certainly. But I think as an IC myself, I on occasion I'm the IC, and unfortunately fairly often, and I would not be thinking that somebody standing behind the yellow tape may have some really important information about someone who we've already concluded has passed away already.
Right.
So.
Yeah. Usually it's the guy behind the tape was important information about the fire is probably the arsonist.
Well, yeah. I mean, I learned early in my career that every fire you go to, there's kids trapped, there's kids in the, and I always wondered how that happens, but it's like one guy says, do you think there's kid's trapped, and then somebody overhears that. And I heard this kid's trapped, and then somebody feels they've got to come forward and say this kid's trapped, you know, and
God forbid. God forbid.
so it's just that craziness. But here we've got the potential for people with really you know, relevant information for us. And you know, one of my friends, you know, Bill Macaron was suggesting that, you know, you can have people on the phone that maybe you know, a crash sensor, whether it's in an iWatch or in a vehicle, and notifies maybe a dad, and now the dad is calling the dispatch center, and you know, the dispatcher doesn't want to admit that there's been an accident. You know, they don't want to provide any sort of details, but now the person's saying, my son was in an accident. He's at, his watch is saying he's at such and such an address. And,
Yeah.
you know,
Yeah. And
so.
as the telematics, I will say, because our department and my county in New York, which is one of probably 5,000 across the nation, but we use, our dispatcher has rapid SOS. And when, and the iPhone can, if it senses a crash, it will automatically, like your watch and whatever, will automatically notify dispatch that the iPhone has sent a crash detection. But all the time, people are leaving their phones on top of their car. They're flying off. And then we're getting dispatched to, you know, an iOS crash detection. And the phone owners are ecstatic because we find their phone, because it pinpoints within a meter of where the phone is. And so we're finding their phone. But on the other hand, we just sent, you know, $2 million of apparatus to find this guy's iPhone. But yeah, technology is playing a huge role in this. And it's going to get even more interesting as technology, you know, rolls out. What did we know? What could have we known? What should have we known? You know, after East Palestine, the train derailment, what could have we known? What should have we known? There's a lot of that. There's why didn't you have this technology? Why didn't you use this technology? Was the technology accurate? It's
The dispatcher hung up on somebody. Oh my God. You know, just think about the implications. Just terrible.
It's incredible. Incredible. Well, okay. That's it for this week.
That's it. And I apologize. I'm a little bit under the weather here. I got into Clearwater, Florida I got a week's worth of training down here, but I was up at 4 o'clock in the morning, and you know, just the travel stuff. So, but
be well.
you're headed out of town. You're headed to.
I'm headed back to your area. I'm headed to Boston. So, anyway, the fire departments want to hang out, let me know.
All right. Well, that's going to do it for another edition of Fire Law Roundup. Thank you, everyone, and hopefully we'll see you again next week. Thanks, Brad.